Social media side income on an H-1B visa. One small mistake can become a big problem. Imagine an Indian tech professional working in America returns home from office at night. All day, he works for his approved H-1B employer, and on weekends, he uploads cooking videos on Instagram as a hobby. Sometimes he bakes cakes for friends, sometimes he gives fitness tips, sometimes he styles someone's hair and uploads a reel. He thinks this is just passion, nothing serious. But during visa stamping, the officer does not look at his phone. The officer looks at his public profile, and suddenly the question changes. Are you also working outside your approved job? The fear begins here. Because working in America on an H-1B visa is still the dream of lakhs of professionals. But this visa is not a freedom pass. It is a status connected to a specific employer, specific role, specific location, and specific work conditions. If an officer sees social media and feels that the visa holder is providing services, running a business, or earning side income outside approved employment, then the matter is no longer just about one post. It can reach visa compliance, unauthorized employment, and future immigration risk. And curiosity is born here. Can an Instagram reel, YouTube video, or hobby content really become a problem for an H-1B worker? Can work done without payment also create doubt? Can activities like cooking, fitness coaching, hairstyling, photography, online teaching, or a small side business bring visa trouble? And the biggest question, what precautions should H-1B holders take on social media so that the line between hobby and unauthorized employment is not crossed? First, understand H-1B in simple words. It is a temporary work visa of America given to foreign professionals working in a specialty occupation. According to USCIS, H-1B classification is for people who want to perform services in a specialty occupation. This means the visa does not give a person open permission to do every kind of work in America. Instead, it connects the person to the employer and job on the basis of which visa approval was received. That is why unauthorized employment is a very sensitive issue for H-1B holders. If a person's approved H-1B employer is a software company, but on a public profile, he presents himself as a paid fitness coach, freelance designer, makeup artist, cooking service provider, real estate promoter, or paid consultant, then the immigration officer may ask questions. The question is not whether the person is talented or not. The question is whether that work comes within his H-1B authorization or not. According to a recent Financial Express report, immigration lawyers have warned that Instagram posts, side hustles, and casual hobby content can also trigger scrutiny for H-1B workers because consulates and USCIS are looking at online activity as possible evidence of unauthorized work. The report mentioned a YouTube immigration update by lawyers Rahul Reddy and Emily from Reddy and Neumann PC, where they said that in some cases, visa stamping or H-1B extension problems were seen because of Instagram posts. One thing must be understood very clearly here. Every social media post is not illegal. Every hobby is not a risk. Every reel is not a problem. If a person cooks food for himself and shares a recipe, posts a running video, shares a gym journey, learns photography, or makes a personal travel vlog, then it does not automatically become unauthorized employment. But the problem begins when the same content starts looking like a service, business, monetization, or client work. For example, if an H-1B holder cooks at home on weekends and shares recipes, it may look like a personal hobby. But if he posts, "Order now, DM for catering, weekend meal service available," or puts up customer testimonials, then an officer may see it as a business activity. If someone shares a fitness journey, that is a different matter. But if the profile bio says, "Online coaching available, paid plans, DM for training," then it can become a signal of side work. Similarly, hairstyling or makeup content can also be risky. If someone is styling a friend's hair and uploading a casual reel, the context will be important. But if the caption mentions appointments, pricing, a booking link, or client transformation, then it may look like a service. The core point of the lawyer's warning is that the immigration officer does not only look at your intention, the officer looks at public evidence. If the public evidence looks like work, questions can arise. Business Standard, citing Reddy and Neumann's immigration update, wrote that day ek CPT, unapproved H-1B work locations, and side work visible on social media can act like legal landmines. The report also said that even an Instagram page can trigger visa refusal if it gives the impression of unauthorized work. Now let's talk about social media scrutiny. Checking online presence in the US. Visa process is no longer new. According to Stanford Bechtel International Center, US, Consulates worldwide can review visa applicants' social media and online presence as part of the visa adjudication process. It also said that for H-1B and H-4 visa applicants, expanded screening was included in the category, expected to begin from 15 December 2025. Indian Express reported in March 2026 that US visa applicants, including H-1B and student categories, are being asked to keep their social media profiles publicly accessible as part of expanded screening requirements. This means online presence can now become an indirect part of the immigration file, not just personal expression. The trickiest thing for H-1B holders here is monetization. Many people say, I didn't take money, so why is there a problem? But lawyers say that even non-monetized content can raise questions if it looks like a service being provided to others. In immigration adjudication, perception becomes very important. If a post has service language, customer interaction, a public offer, or brand promotion, the officer may ask whether this was employment or business activity. YouTube monetization, affiliate links, sponsored posts, brand collaborations, and paid subscriptions can also be sensitive. If an H-1B holder is earning income from a personal channel, is it passive income or active work? This question depends on the facts. If ad revenue is coming only from old content, that may be one situation. But if the person is regularly creating content as a commercial activity, making brand deals, and selling services, then the risk can increase. That is why in such cases, taking personal legal advice from an immigration attorney is very important. The biggest rule of H-1B is that you work for your petitioning employer in the authorized role. If the job location changes, the role changes, the employer changes, or you have to work for an additional employer, proper filing and authorization may be required. Side hustle culture may look normal on American social media, but under H-1B status, the same side hustle can become an immigration violation. Today, the problem has increased because social media has blurred the boundary between hobbies and business. Earlier, if a person baked a cake at home, it was a hobby. Now the same cake appears on an Instagram page, the caption says DM to order, payment comes through UPI or Zelle, and slowly the hobby becomes a micro business. For a citizen or green card holder, this may be entrepreneurship, but for an H-1B holder, this can become a risk. Lawyers have also said that the official rulebook does not very clearly explain where a hobby ends and unauthorized employment begins. This uncertainty forces H-1B holders to become even more careful. If the line is not clear, the safest approach is not to present yourself publicly as a service provider, coach, seller, consultant, or business operator unless you have proper authorization and legal clarity. This fear is not limited only to visa stamping. H-1B extension, amendment, transfer, green card process, and consular interview can also raise questions about online activity. If the officer feels that the applicant has violated status, the case can reach delays, administrative processing, request for evidence, denial, or future inadmissibility issues. Every case is different, but the risk is real. Reuters reported on 29 April 2026 that the US government is implementing enhanced security checks for immigration applicants, and officers have been instructed not to approve cases without the required checks. This shows the broader enforcement climate, where scrutiny in immigration adjudication is increasing. In such an environment, H-1B workers should not take their digital footprint lightly. Public posts, captions, hashtags, bio, booking links, payment links, reviews, client photos, collaboration tags, and even comments can create context. If people are writing on a post, "What is the price? Can I get an appointment? Can I book you?" and the profile owner is replying like a service provider, then this can become a red flag for an immigration officer. Now the question is, what is safe? Safe is where the activity is clearly personal, non-commercial, and non-service oriented. If you like cooking, you can share recipes, but avoid language that accepts orders. If you like fitness, share your journey, but do not sell coaching packages. If photography is your hobby, share photos, but do not take paid shoot bookings. If teaching is your passion, posting general educational content may be different, but advertising paid classes can be risky. There is another nuance here: volunteering. If an H-1B holder volunteers for a non-profit, caution is still needed. Not every volunteer work is safe. If the same work is normally done by a paid employee and you are doing it for free, the question of unauthorized work can still arise. So being unpaid does not always make something safe. In immigration law, "I did not receive payment" and "I did not work" can be two different things. H-1B workers should also be careful with spouses, friends, or influencers. Sometimes being tagged in someone else's post can also raise questions. For example, a friend writes about you, best photographer in town, DM him for bookings, and you are on H-1B, then this can become public evidence. Even if you did not start a business, the online impression can look like a service. If someone has already posted such content, they should not panic, but do a thoughtful cleanup. Remove misleading captions, remove booking links, clear monetized service claims, and keep personal hobby context in future content. But if you have done actual paid work, simply deleting the post does not solve the legal problem. In such a case, honest consultation with an immigration attorney is necessary. H-1B holders should also understand the tax angle. If side income has been received and shown in the tax return, then the immigration officer may ask which authorized work this income came from. If a mismatch appears between income tax records and immigration status, trouble can increase. That is why treating side income as a small amount and ignoring it is not right. This issue is relevant for employers too. If an employee is running a side business on a public profile, the employer may also face compliance questions, especially if the employee's work authorization is strict. That is why many companies clearly explain policies related to external work, consulting, freelancing, and conflict of interest to employees. An H-1B worker should understand both company policy and immigration law. The saddest part of this whole story is that many people take risks not with the intention of doing anything wrong, but because of ignorance. They think everyone does side hustles in America, so they can too. But immigration status decides rights and restrictions. A citizen, permanent resident, student, H-1B holder, and GRT holder can all have different work authorization. So making your decision by looking at someone else can be dangerous. For H-1B workers, the practical rule is simple. Be very careful about any work that you're not doing for your approved employer, and that creates the impression of a service, business, income, client, or promotion. If there is doubt, think before posting. How would a visa officer read this? The officer will not see the intention in your heart. The officer will see the caption, profile, link, and pattern. Also remember that social media works almost like a permanent record. A post can be deleted, but screenshots, tags, cached pages, and third-party mentions may remain. During a visa interview, if the officer asks questions from your public profile, lying would be the biggest mistake. Misrepresentation is a very serious issue in immigration law. If an activity has happened, then a truthful strategy with attorney guidance is necessary. Now, a special point for content creators. If you are on H-1B and want to create YouTube, Instagram, or TikTok content, first understand whether the content is a hobby or a business. Are you getting brand deals? Is ad revenue coming in? Is there affiliate income? Are you selling products? Are you booking consulting calls? Are you selling courses? The answers to these questions will decide your risk profile. Some people think that if the income is coming into an Indian account, why would US immigration care? But if the work was physically done while living in America, the payment location does not remove the risk. H-1B status restricts your work activity while you are in the US. Therefore, a foreign client, foreign payment, or foreign account does not automatically make it safe. This script is not meant to spread fear, but to create awareness. H-1B visa holders are hardworking professionals who have built their place in America on the basis of education, skills, and employment. But in the immigration system, compliance is very important. One small digital mistake can put years of hard work into difficulty. That is why caution is not weakness, it is smartness. If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible. But in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.